Good morning or good afternoon, depending on where you may be joining us today. Thank you for attending today's presentation, Employment Law in Focus, the Impact of Trump's 100 Days. While this session is hosted by CISA, the global leader in background screening and compliance-driven human capital and risk management solutions, we're delighted to welcome attendees from across our family of brands. Whether you registered through PreCheck, DriverIQ, or one of our other divisions, thank you for joining us. Today's webinar is presented by Arnold Golden Gregory, an AM Law 200 law firm with expertise in industries such as healthcare, transportation, technology, and global commerce. Also, please keep in mind that this presentation is intended for informational purposes only. Neither this presentation nor the material presented during the webinar should be construed as legal advice. Again, thank you for joining us today. Without further ado, I'm excited to introduce our speakers, Kevin Coy and Lindsay Locke from Arnold Golden Gregory. Kevin and Lindsay, please take it away.
Thank you, everyone, for joining us today. My name is Kevin Coy. I'm a partner in AGG's Washington, D.C. office. I'm also co-chair of our privacy and cybersecurity practice, as well as a member of our background screening industry team and member of the firm's pro bono committee and our diversity, equity, and inclusion committee. Lindsay?
Hi, everybody. I'm Lindsay Locke. I'm an associate in AJG's Atlanta office, and I'm a member of our litigation and employment law teams.
For our agenda today, the new administration has been very busy. As you may have seen in the press, we're right at the 100th day of the administration, a traditional benchmark of taking stock on how a new administration is getting off to a good start. You'll see in the media, if you haven't already, many a story about where we are at the 100th day of the Trump administration overall. We're going to take a little more narrow focus of that, looking at employment areas of concern and developments through a prism of what's going on here in Washington. And so we're going to talk about Trump administration agency activity in terms of staffing the agencies and changes at the agency level, particularly for those that have implications for employment. We're going to look at developments with respect to diversity, equity, and inclusion, a recent executive order that the president issued with respect to disparate impact as a theory of liability under Title VII of the Civil Rights Act and other civil rights laws, as well as immigration developments, recent Supreme Court developments. Although with those, some of those predate the new administration, but they're still shaping the environment. The developments with respect to the Pregnant Workers Fairness Act, as well as some privacy and background screening developments that are in the offing. Looking at the administration's staffing with respects to agencies, there's the old adage that personnel is policy, and that's certainly true in the new administration, as the president has moved quickly to put his mark on the Equal Employment Opportunity Commission, the National Labor Relations Board, the Federal Trade Commission, the Department of Labor, the Consumer Financial Protection Bureau, all of which have touches to varying degrees on employment law considerations. And while in some administrations, this slide is relatively static, if you were thinking about doing this for each new administration, it's been very vibrant here for the new administration. At the Equal Employment Opportunity Commission, President Trump has renominated Commissioner Andrea Lucas for an additional term. Her term has been set to expire. He also has named her as acting chair of the EEOC, but not named her as permanent chair. In addition, there are currently 3 open seats at the EEOC, and you see an asterisk there on the slide for open seats for several of these agencies. And that's because litigation is ongoing. What's really going on there at a broad level is the President Trump has dismissed 1 or more commissioners at the EEOC, the FTC, the National Labor Relations Board, without going through the 4 cause requirements that those enabling statutes have. The president asserts that he has the ability to fire commissioners for any reason as part of his responsibilities as president. The terminated commissioners at the various agencies, at least one at each agency, is pushing back, suing that they've been wrongfully terminated. And that litigation is ongoing. One of those cases is currently at the Supreme Court with decisions forthcoming as to how the court's going to proceed in hearing those cases. At the root of this question of how much authority the president has over independent agencies, and whether a Supreme Court precedent from the 1930s, which said in the case of the FTC in particular, that termination could only be made for cause, is still good law. That has a big impact on how some of these agencies can or cannot operate, because some of them don't have a quorum. The EEOC, for example, has 3 open seats currently. They therefore don't have a quorum to operate, and they're limited in what they can do. They can carry on some routine functions, but they can't make major policy decisions without a quorum. And so for now, their ability to act is limited, although some routine activity is continuing, and you'll see some announcements of some settlements in some relatively routine cases, but they're also limited in terms of their ability to make new policy, which is going to come up with respect to some of the content that Lindsay's going to be talking about a little bit later, as well as some of the content that I'm going to be talking about with respect to DEI activities. At the Federal Trade Commission, the president named Andrew Ferguson as permanent chair. He also terminated 2 Democratic commissioners, although in the meantime, his nominee to fill one of the open seats, Commissioner Mark Mador, was sworn in on April 16th. So the FTC has 3 commissioners currently and is fully operational. The National Labor Relations Board has 3 open seats. One of the terminations there is the case that's before the Supreme Court. They are limited in what they can do, although the commissioner that was terminated there has, in the course of suing for reinstatement, has been temporarily reappointed or reinstalled, restored to her seat off and on as this case is proceeded through the courts. And the NLRB took advantage of one of the periods where she was restored to office. She's not currently in office, but when she was restored in late March, push out 3 decisions. Labor Department, Secretary Lori Chavez de Grimmer, the former congresswoman from Oregon, has been confirmed as Labor Secretary, and the Labor Department is moving forward with its activities, although they're looking to downsize staff in a variety of offices. And to CFPB, Russell Vought, the OMB director, is currently acting CFPB director, while the president's nominee to become director, Jonathan McKernan, is awaiting confirmation by the Senate. He's been approved by committee. He's waiting a floor vote in the full Senate. That Senator Tim Scott from South Carolina expects may happen as early as mid-May. With those personnel changes, we also in Washington and at these agencies are seeing a host of other activities with respect to the president's approach and the new administration's approach to the federal government overall, and these agencies in particular, including the activities of DOJ, the president's assertion of authority over independent agencies, which we were talking about a moment ago, impacting the president's decision to terminate commissioners at the various independent commissions. In addition, the president, when he first took office, put in place a regulatory pause on all new regulations for 60 days. That pause has ended, but the administration also, through another executive order, the president has instructed agencies to essentially cut 10 regulations or guidance documents or other instrumentalities for every new one that they institute. And through other executive orders, he's directed the agencies to take a look at existing regulations across the government to identify regulations that may impose undue burdens or otherwise be unconstitutional, signaling that the administration has a strong intention and inclination to try and reduce the regulatory burden on businesses across the board. And so we'll have to see how those activities play out in practice. Some of those repeal efforts may be expedited without all of the procedural requirements that the Administrative Procedures Act might require. The administration is looking for ways to speed up the regulatory repeal process, which also may result in some litigation about efforts to repeal some of those regulations. but that's part of the broader environment here, as well as the president relying heavily on executive orders to try and move forward the new administration's agenda. So far, the president has issued about 142 executive orders since he took office on January 20th. We're on day 100. There's a cabinet meeting today, so we may still get a few more yet today before we close out day 100. For comparison purposes, President Biden issued 162 executive orders over the course of his entire administration. And President Trump's first administration, during that time, he issued 220 executive orders over that entire period. Again, at least 142 so far here. And with that, switching over to the first major substantive area of our discussion today, the administration's approach to diversity, equity, inclusion. This has been a priority for the administration, seeking to roll back what the administration sees as overreach with respect to DEI issues. On January 21st, second day back in office, President Trump issued Executive Order 14173 on ending illegal discrimination and restoring merit-based opportunity. This order sets the framework for the administration's approach to DEI issues, repeals a number of executive orders on diversity and equal opportunity issues, including one that had been issued by President Johnson back in 1965 regarding non-discrimination by government contractors. It orders all agencies to terminate, quote unquote, all discriminatory programs and activities and to combat illegal private sector DEI preferences, mandates, policies, programs, and activities. It also requires a report from all federal agencies within 120 days, so by roughly May 20th, with recommendations for enforcing federal civil rights law and taking other measures to encourage the private sector to end illegal DEI discrimination and preferences. Also requires a strategic enforcement plan from the Attorney General in consultation with relevant agency heads to help formulate appropriate and effective civil rights policy so that the administration is going to recast and refocus its approach to civil rights law, including taking action where they see DEI measures that they believe are unlawful. That strategic plan is required to identify key sectors of concern within each agency's jurisdiction, including the most egregious and discriminatory DEI practitioners in each area of concern, quote unquote, as well as a plan of specific steps and measures to deter DEI programs or principles that constitute illegal discrimination or preferences, whether specifically denominated as DEI or otherwise. In other words, suggesting that simply changing the names of the initiatives will not be sufficient, but rather they'll look at the substance of the underlying programs. Some concern that the requirement to identify the quote unquote most egregious and discriminatory DEI practitioners in each area of concern will lead to naming of companies and potentially shaming of companies in this area where the administration believes that they have overstepped. Each agency is to identify up to 9 potential civil compliance investigations with a focus on publicly traded corporations, large nonprofits, foundations, higher education institutions, namely those with $1 billion or more in endowments, as well as state and local legal bar and medical associations. There's been some litigation over this executive order already, and on March 14th, the Fourth Circuit lifted a preliminary injunction against parts of this executive order, although the legal challenges remain. There also has been a host of other activity around this at the agency level already. On March 17th, EEOC Acting Chair Lucas sent a substantially similar letter to 20 different major law firms with detailed requests for information about their DEI practices. Those responses were due April 15th. DEI has also been a factor in other executive orders focusing on specific law firms, as well as litigation over other executive orders and voluntary agreements to avoid executive orders targeting law firms. While law firms have been a primary initial focus of the administration, the executive order clearly identifies other sectors across the economy where this will be an area of focus. And so it's something to take a look at. You may want to take a look at the questions that Acting Chair Lucas sent to the law firms. They have 37 questions, varying slightly in some of those letters, but asking for detailed information about DEI practices. In addition to the executive orders, on March 19th, the EEOC and DOJ issued technical assistance documents that address unlawful discrimination related to DEI in the workplace. And the document notes that DEI initiatives, policies, programs, or practices may be unlawful if they involve an employer or other covered entity taking employment action motivated in whole or in part by an employee's or applicant's race, sex, or other protected characteristic. This is available on the EEOC website, something you want to consider reviewing with your legal counsel. Lindsay's also going to discuss a Supreme Court case that's pending that also could have some implications here as well. In addition to reviewing this with counsel, some factors to consider from a DEI perspective. First, confirm your status as to whether or not your organization is a supplier or a contractor to any federal department or agency, because government contracting rules are also being reviewed in this area, and that could have implications for how you approach DEI within your organization. In addition, consider reviewing your workplace policies and programs for anything that may be viewed as preferential treatment on the basis of gender, race, or other protected characteristics. Areas to consider may include affinity groups. If they limit membership, they may be limited or they may be subject to additional scrutiny. Similarly, internships or training or mentoring programs that focus on gender or race may be considered illegal depending on how they're structured, as well as race or gender-based employment or hiring targets, which are also clearly under scrutiny here. In addition to the position that the administration is taking, also consider your actions here in the context of Supreme Court decisions around this. There was a Supreme Court decision a couple of years ago involving Harvard and affirmative action activities, which raises some questions for particular aspects of DEI, which your organization may consider as you think through how your organizations are going to approach DEI issues going forward. Many organizations are reevaluating their DEI programs. Some are making tweaks, some are standing pat, others are making more extensive changes, but really a question of what your existing programs are and how you want to approach those going forward. Just last week, we got a new disparate impact executive order from President Trump, Executive Order 14281, addressing disparate impact in the context of Title VII of the Civil Rights Act, as well as other civil rights laws where it crops up across the federal government. By way of background, disparate impact cases, if you're not familiar, are instances where a plaintiff alleges that an employer or another actor has engaged in discriminatory conduct, not because they were specifically intending to discriminate, but rather because a facially neutral criterion had a disparate impact on a particular protected class. For example, in a classic Supreme Court case on the issue, a company had requirements for a high school diploma and for certain intelligence testing. This was back in the 1970s. And the Supreme Court upheld the challenge there, arguing that there was no business relationship between the diploma requirement and the disqualification for the particular positions at issue, and that it had a disparate impact on African-American applicants. And so that's just one example of how this might arise. Since then, it's been incorporated or addressed in a number of civil rights laws, including Title VII, where this disparate impact theory was codified in 1991. On April 23rd, the president issued this new executive order, just a week ago, on restoring equality of opportunity and meritocracy. It declares that it's the policy of the United States to eliminate the use of disparate impact liability in all contexts to the maximum degree possible to avoid violating the Constitution, federal civil rights laws, and basic American ideals. It instructs federal agencies to deprioritize enforcement of statutes and regulations to the extent they include disparate impact liability. It also requires the Attorney General and the chair of the Equal Employment Opportunity Commission to issue technical guidance to employers regarding, quote, appropriate methods to promote equal access to employment, regardless of whether an applicant has a college education where appropriate, expanding the rationale of that Supreme Court case that I mentioned, which was focused on high school diplomas. So we'll have to see where that future technical guidance may take us. It also requires a series of other steps be undertaken within the next 30, 45, and 90 days. Within 30 days, it requires a report from the Attorney General in coordination with other federal agencies identifying all existing regulation, guidance, rules, and orders that impose disparate impact liability or similar requirements, and detailing agency steps for their amendment or repeal as appropriate under applicable law. It also requires that there be a review of other laws and decisions, including at the state level, that impose disparate impact requirements, and steps to address any constitutional or other legal infirmities. Another part of the order separately requires the Attorney General and agencies to determine whether these state laws, regulations, or policies may be either preempted by federal civil rights law or in otherwise need of potentially being challenged through appropriate measures. Within 45 days, the AG, the EEOC chair, as well as similar reviews at other agencies are to be undertaken with respect to all pending investigations, civil suits, and positions that the agencies are taking across their litigation portfolios to review any disparate impact claims or counts that those cases involve and take action consistent with this executive order, which would suggest that those claims are likely to be withdrawn. And within 90 days, all agencies are required to go back and reevaluate existing consent judgments and permanent injunctions that relied on disparate impact liability and look to roll those back. Depending upon the particular circumstances, those earlier decisions and orders may be reopened, or the departments may seek to reopen those cases to potentially change the terms of those requirements. And with that, let me turn it over to Lindsay to talk about immigration developments and some of the other developments we're looking at today. Lindsay?
Good afternoon, everybody. We're going to turn now to the immigration developments in the first 100 days of the Trump administration, which has been another kind of hot topic. I'm sure everybody's seen it in the news. So immigration obviously has been and continues to be a priority for the Trump administration. A lot of the activity in this area is also coming in the form of various executive orders. As I was saying, a lot of this activity has been in the form of executive orders. This list here is obviously not exhaustive, and this is a high-level summary of some of what we're seeing in the immigration space. But a few of the orders that have come down. First, we have one that was called the protecting the U.S. from foreign terrorists and other national security and public safety threats. This order, its purpose was to direct federal agencies to implement stricter vetting for visa applicants. So this is aimed at putting a more stringent process in place for people who are seeking visas to enter the United States for a variety of reasons. We also have the executive order protecting the meaning and value of American citizenship. I'm sure everybody has seen this one in the news. This is the order that's purpose was to limit birthright citizenship for those who are born in the United States to only those who have at least one parent who is either a legal green card holder or a U.S. citizen. This has already been the subject of litigation and challenges from multiple groups. And the Supreme Court is actually supposed to hear argument on this executive order next month. So there will be an update sometime soon on the validity of that executive order. We also have the executive order titled Securing Our Borders. This is mainly to secure the southern United States border with Mexico to stop unauthorized entry at the Mexican-U.S. border. And it also terminates certain humanitarian parole programs that were allowing individuals from Cuba, Haiti, Nicaragua, and Venezuela to come in under humanitarian purposes. And we also have the executive order protecting the American people against invasion. This expands the use of expedited removal procedures to get undocumented, unauthorized individuals out of the country faster. It also revokes certain Biden executive orders that allowed asylum and other types of immigration programs. It requires undocumented immigrants to register their presence in the United States, and it denies certain federal funds to sanctuary jurisdictions. So this is an overview of what's going on in the immigration space from the Trump administration. But obviously, we're here to talk about employment. So how does this impact employers? So in the employment context, we expect to see some increased activity in the immigration space. We expect to see an increase in I-9 audits at employers and worksite enforcement actions where ICE comes on site to an employer. Those in the immigration field estimate that audits will increase to 12,000 to 15,000 a year and over 100 worksite enforcement actions. For context, during 2018 and 2019, under the prior Trump administration, we saw roughly 6,000 I-9 audits and 50 on-site worksite enforcement actions during that time. So we expect to see double in those annually from those types of enforcement. We also expect that certain industries will be more heavily targeted with immigration enforcement in the employer space, and those would be construction, hospitality, manufacturing, and food processing, agriculture, and then critical infrastructure industries, which include things like transportation. We also expect that visitors to the U.S., including those who are here for tourism or business purposes, will be more heavily scrutinized upon entering the United States. This may even result in some business visitors being denied entry at the border at customs and being required to go back, get work visas, and then come back for any business-related reason. And then we also expect to see delays in visa and green card processing for employment-based applicants. So if this is something that you often have to do in your business, if you're bringing over a lot of people from other countries for business purposes, we expect to see delays in the processing time for those types of applications. Another thing that Kevin alluded to is that we've seen some developments in the Supreme Court level during the first 100 days of the Trump administration. Obviously, these decisions are not directly controlled by the administration, and some of these cases do predate the current administration, but all these cases have been argued and or decisions have been handed down during the first 100 days of the Trump administration. So the first case that we've actually gotten a decision from the Supreme Court on in the employment context is in the EMD Sales versus Carrera case. And this case involved an issue of the burden of proof in FLSA action, so in overtime wage action. So the question before the court on this case was what is the burden of proof for employers who are trying to prove the applicability of the overtime exemption under the FLSA. So they're trying to prove that an employee is exempt from the overtime requirements of the FLSA. And the question was whether those employers have to meet a preponderance of the evidence standard, which is the normal burden of proof in civil litigation. It's essentially, is it 51% likely that this person meets the exemption, as opposed to, I'm sure everybody's heard of beyond a reasonable doubt in criminal cases is a much higher standard. And there's also the clear and convincing evidence standard, which is a higher civil litigation standard. So they were trying to determine whether the employer had to prove the applicability of the overtime exemption by a mere preponderance of the evidence, or if they were going to have to meet this higher clear and convincing evidence standard. And 3 former sales employees of EMD sued, claiming that they were entitled to overtime under the FLSA and were not paid that overtime. The employer so that they were exempt under one of the sales exemptions to the FLSA and were not entitled to overtime. At the district court level and at the Court of Appeals, they determined that the employer was required to prove the overtime exemption applied by clear and convincing evidence, and they had not met that burden. The Supreme Court disagreed and reversed that decision, saying that no, there's no reason that higher burden should be applied here. Employers only have to meet the preponderance of the evidence standard. So this makes it easier for employers to prove that one of those exemptions applies. The next case was Lackey versus Stinney. This was not directly an employment decision, but it involves civil rights litigation that may have civil rights statutes that may have an effect on employment discrimination cases. So in this case, some Virginia residents challenged a state statute regarding suspension of driver's licenses for failing to pay certain court fines. They sued under 42 U.S.C. 1983, which allows for civil rights suits against state and local governments. And in the process of challenging this driver's license statute, they got a preliminary injunction saying that it was unenforceable. And after that, before the case made it to a final decision on the merits, the statute was repealed. So the case became moot. And the question before the Supreme Court on this was whether they were entitled to their attorney's fees as a prevailing party under civil rights statute for getting a preliminary injunction, even though no decision was ever made on the merits. And the court determined that a preliminary injunction, a party that receives a preliminary injunction but does not obtain a final judgment before the case becomes moot, is not a prevailing party. And so this was interpreting the prevailing party attorney's fee statute that applies to Section 1983 claims and also Section 1981 claims, which are also brought in the employment context. So this could affect the ability for employees to get attorney's fees in civil rights cases in the employment context as well. Now we have two cases that have been submitted to the Supreme Court. The Supreme Court has held oral argument, but we do not yet have a decision yet. We expect one any day now. So the first one is Ames versus Ohio Department of Youth Services. And this case goes back to some of what Kevin was saying about the DEI initiatives under the Trump administration, because this case essentially involves the standard for proving employment discrimination for a reverse discrimination claim as opposed to a traditional discrimination claim. So for some background of this case, some district courts, federal district courts, have held that when a member of a majority group as opposed to a member of a minority group is trying to prove an employment discrimination claim, that those individuals need to make an additional showing that there are background circumstances suggesting that the employer is an unusual employer that discriminates against majority groups. So essentially, there is a standard in some courts that makes it harder for a member of a majority group to prove employment discrimination. And so the question before the court on this case is whether that is the correct standard, or if those members of majority groups simply have to meet the same burden as anybody else trying to make an employment discrimination case. So the facts here are that the plaintiff, Ms. Ames, was employed by the Ohio Department of Youth Services. Back in 2017, she was assigned a new supervisor who was gay. Ms. Ames is a heterosexual woman. In April 2019, she applied for a promotion and was denied by that supervisor. And then shortly thereafter, it was suggested to her that she consider retiring, and she was eventually demoted and took a pay cut. After that, a gay man who was younger than her was promoted to her original position. And later that year, a gay woman was promoted to the position that she had applied for, but had not been selected. And so she's filed a lawsuit under Title VII claiming that she's been discriminated against due to her sexual orientation. And the district court dismissed her claim on summary judgment, saying that she as a member of the majority group, had not made this additional showing that there are circumstances suggesting that her employer would discriminate against a majority group. Dismissed her claim. The Court of Appeals affirmed, and so that's currently up before the Supreme Court. And when they decide this, this is essentially going to be a decision about whether it's harder to prove reverse discrimination claims. So this kind of goes along with a lot of the DEI initiate the DEI executive orders going on in the Trump administration currently. The second case that has been argued that we expect a decision on any day now is Stanley versus City of Sanford. This actually involves ADA disability litigation. And so the question here is whether a former employee who was qualified to perform her job and earned post-employment benefits while employed still has the right to sue over discrimination related to those benefits once she retires. So Ms. Stanley was a firefighter in Sanford, Florida. She retired in 2018 after a Parkinson's diagnosis. And when Ms. Stanley was first joined the firefighting force in 1999, they had a policy that stated that those who retired due to a disability, like Ms. Stanley, would receive insurance benefits through the age of 65. At some point, that policy changed to where only those who retired due to disability would only receive insurance for 24 months after their retirement. Ms. Stanley is sued, claiming that this was discrimination against retirees with disabilities under the ADA. And the 11th Circuit on appeal determined that she could not maintain her claim because she was retired, was no longer an employee under she was no longer considered an employee under the ADA. So this decision, whenever it comes down, will determine whether retirees may have standing to make ADA or other civil rights claims, discrimination claims. And finally, there's been some developments in the Pregnant Workers Fairness Act, specifically related to challenges to the final rule issued by the EEOC. As I'm sure everybody is aware, the Pregnant Workers Fairness Act is a statute that went into effect in June 2023. It requires employers with 15 or more employees to provide reasonable accommodations to employees who have limitations relating to pregnancy and childbirth or other related medical conditions. Last April, the EEOC announced a final rule implementing this statute, which is pretty broad in respect to the accommodation requirements related to pregnancy conditions. So the final rule explained that certain employees may be qualified under the Pregnant Workers Fairness Act, even if they are unable to perform one or more essential functions during the period of that limitation, as long as it's temporary. So under the statute, an employer may have an obligation to provide accommodations to an employee who is suffering from a pregnancy or childbirth-related disability, even if that employee is temporarily unable to perform essential functions of their jobs. And in terms of what temporary means, these rules generally consider temporary to mean the entire length of a pregnancy. So you're looking at potentially close to a year, 40 weeks, where you may have to accommodate somebody who's unable to perform the essential functions of their job. So this kind of expands the disability accommodation requirements of the ADA as it relates to pregnancy or childbirth. So there have been a lot of challenges to the final rule issued by the EEOC as it relates to the Pregnant Workers Fairness Act. The first of these was in April of 2024. Republican attorney generals from 17 states filed suit against the EEOC, challenging the final rule as it relates to accommodations for abortion. And most, if not all, of these challenges relate to abortion-related accommodations. The case was originally dismissed by the district court, claiming the attorney general did not have standing. But on February 20th of this year, the 8th Circuit Court of Appeals ruled that they did have standing, and that challenge is going to proceed. In June 2024, the Western District of Louisiana partially enjoined enforcement of the final rule for certain workers in Louisiana and Mississippi and postponed the effective date. And those challenges also related to accommodations for elective abortions that were not necessary to treat a medical condition. In March 2025, a Missouri federal court ruled that the EEOC could not enforce the final rule against a religious organization, reasoning that the plaintiff could show that the final rule is contrary to constitutional principles. And then most recently, in April of this year, the U.S. District Court for the District of North Dakota issued a permanent injunction prohibiting the EEOC from enforcing the Pregnant Workers Fairness Act against the Catholic Benefits Association and the Diocese of Bismarck in a manner that requires accommodation for abortion or fertility treatments. So there have been a lot of challenges to this final rule. Some of these will still play out, but most of them relate to requirements to provide for abortion or fertility treatments. And finally, as Kevin previewed with the uncertainty related to the EEOC chair position, the current acting chair, Lucas, voted against the final rule in April 2024. And she does remain opposed to the commission's construction of the phrase pregnancy, childbirth, or related medical conditions. But as Kevin previewed, the EEOC does not currently have a quorum, so they cannot currently take any action to either rescind or modify this final rule. So it'll be interesting to see what action they take related to this final rule when there is some more certainty in the EEOC staffing and they have a quorum again and are able to make these larger policy related decisions. So now I'm going to turn it back to Kevin to discuss the privacy related updates.
Thanks, Lindsay. And as we swing to now to privacy and background screening developments, just to close the loop on what Lindsay was saying, with the EEOC, they only have 2 commissioners presently. There are 3 vacancies. President Trump has not yet nominated anyone for those 3 seats, although, as I mentioned, he did renominate acting chair Lucas for another term for the seats she currently holds. So it may be a little while before we get that relevant quorum back at the EEOC. They are continuing to issue technical guidance and taking other steps. The technical guidance we were discussing earlier with respect to their approach to DEI issues makes the point, reflecting what Lindsay was saying about the Supreme Court case regarding majority or reverse discrimination cases. In the administration's view, that terminology, although it's what's traditionally has been used, isn't the best way of looking at it from their vantage point. They would characterize discrimination as being the same across the board, regardless of whether it's a majority or minority population. So depending on where the Supreme Court comes down in that case that Lindsay was discussing, with respect to privacy and cybersecurity developments, 3 issues that we wanted to flag for attention and potential consideration here. At different agencies, they're at different stages in the process. First, at the Consumer Financial Protection Bureau, in December of last year, as the Biden administration was wrapping up its work, the Consumer Financial Protection Bureau proposed a Fair Credit Reporting Act rulemaking. They've been working on that for the last couple of years. They included a number of proposals in that notice of proposed rulemaking, which, if they were adopted as the agency had proposed them, could expand the functional reach of the Fair Credit Reporting Act, could bring additional services within the scope of the FCRA. It also includes a number of proposals that affect how consumer reporting agencies operate, but from an employment perspective, the primary focus or primary potential impact is that it could bring additional services within the scope of the FCRA, which would then, in the employment context, require disclosure and authorization before that information could be obtained. But this is only a proposed rule at this point. The public comment period on the proposal closed on April 2nd. That is, the CFPB, after President Trump took office, extended the public comment period to April 2nd from March 3rd, effectively giving folks another month to comment on the proposal. That proposal is now closed, and we now wait to see what the CFPB is going to do with it. They have not withdrawn the rulemaking, which is something that many anticipated when the new administration was coming in. So they could still potentially take action on it. Conventional wisdom seems to be that it won't be adopted in its current form, but we still may see something coming out of it. That'll be something simply to keep an eye on going forward. At the Justice Department, we have a final rule on bulk access to U.S. sensitive personal data by countries of concern. That is a long and arguably boring way to talk about restrictions on transfers of sensitive personal data about U.S. persons to what the reg calls countries of concern, including China, which includes for these purposes Hong Kong and Macau, as well as Russia, North Korea, Venezuela, and a couple of others. It applies to sensitive personal information broadly, and it includes applicability to employment data. So if you're sending personal data abroad in bulk or providing access to employees or service providers overseas to personal data in bulk, and what constitutes bulk varies depending on what type of personal information you're talking about. The regulation applies to certain identifying information, certain personal financial information, health information, geolocation information, biometric information, genetic and economic information. And the thresholds vary depending on which bucket you're talking about. Can range from 100 information about 100 persons in the case of economic data to 100,000 in the case of general identifiers. But if you are sending that information overseas, you have potential considerations under this new rule. And if the data is going to persons in or entities controlled by these countries of concern, you have additional obligations and restrictions there. The regulations include a number of exceptions for certain corporate transactions, so that if data is being transferred in connection with routine HR functions, an exception may apply to facilitate that. On the other hand, if a company has hypothetically a call center in China, that would not be a basis for sending or allowing access to information about US persons so that the call center can carry out its responsibilities. So there are a number of moving parts within that regulation to be considered if it potentially applies to your organization. That it was published in the Federal Register on January 8th. It took effect on April 8th, although some compliance obligations were delayed until October 6th of this year. And DOJ just issued additional guidance on April 11th, including saying that they're going to take a limited enforcement posture until early July, provided that organizations are making good faith efforts to comply. So that is something to think about if you have those sorts of data flows within your organization. Lastly, the Department of Health and Human Services has issued proposed amendments to the HIPAA security rule. In the employment context, that most frequently comes up in the context of HIPAA regulated employer health plans, and by extension, the employers offering those plans through the obligations that the employers undertake through plan documents. It was published in the Federal Register on January 6th. The public comment period closed on March 7th. As proposed, it would require revised information security programs and business associate agreements, not only for group health plans, but all HIPAA regulated entities. It's an effort to update the HIPAA security rule, which hasn't really been revised since the HITECH Act amendments in 2009. HHS is attempting to put in place a more modernized, structured set of information security requirements, replacing those 2009 era requirements, many of which actually dated back to when the security rule was first put in place at the beginning of the century. So that's something else to keep an eye on. It's again at the proposal stage, so it has not yet been finalized. Remains to be seen where the new administration is going to go with it and whether they're going to move that forward to completion, but something else to keep on your radar. And with that, we've got a couple of minutes here, I think, for questions.
I have one question here. How would the Lackey decision apply to and affect employers?
Sure, I can take that one. So the Lackey decision, as I said earlier, was not an employment-related decision involved in 1983 claim. However, the prevailing party attorney's fee statute that would issue is Section 1988, which also controls attorney's fees for Section 1981 claims. As I'm sure a lot of y'all know, employment discrimination claims that are based on race are often brought under Section 1981 and Title VII, and sometimes just under Section 1981, as it doesn't have the same requirements to exhaust your administrative remedies at the EEOC as Title VII does. So to the extent that employment discrimination claims are being brought under Section 1981, the Lackey decision may also affect the availability of attorney's fees should an employee get some type of preliminary injunction in an employment discrimination case.
Next question. Does President Trump's executive order and disparate impact discrimination cases?
Oh, I can take that one. It doesn't necessarily end disparate impact cases. It indicates the administration is going to seek to minimize that activity from a federal enforcement perspective. But disparate impact is built into some civil rights laws. As I mentioned, the Congress amended Title VII in 1991 to add disparate impact standards based on that earlier Supreme Court case that I mentioned. So without action from Congress, there could potentially still be private rights of action, although those potentially need to go to varying degrees through the EEOC. So we'll have to see how that plays out. It also remains to be seen how things play out at the state level. The executive order instructs the attorney general and federal agencies to look at state disparate impact theories and activities and laws to identify whether or not those are potentially preempted by federal law or otherwise constitutionally infirm. So we could also see, on the one hand, litigation seeking to block those types of claims on those sorts of theories, as well as employees or former employees seeking, or applicants seeking to bring more cases under those state laws if they don't feel that they can proceed under federal law. So we're in a bit of a period of uncertainty about that, but it's something to keep an eye on.
If you have any questions about our background check solutions, you can scan the QR code on the screen right now to contact one of our screening experts.